Welcome everybody, and thank you for attending. I'm going to be talking about legal tools used to promote workers, protect workers' mental health as such. It's going to take about 45 minutes, and it's a presentation that ends with about 10 slides of references. So obviously I'm not going to speak to the references, but I'm happy to share these slides with whoever would like to see those references. And I am just trying to advance my slides, which is not working. Yeah, there we go. Okay. So the outline of the presentation, we're going to start off really with an overview of all the different types of regulatory approaches that exist to protect workers' mental health, not specifically in Ontario, but conceptually, regardless of where you are in the world. And then we're going to look specifically at Canada and start with occupational health and safety legislation, which I believe everybody knows is designed to prevent occupational injury and disease. I'm going to say a few words about workers' compensation, and then one slide on voluntary standards, and finally a few words about the recently adopted ILO convention. So in terms of typologies, I put this together actually much before 2017 because people at the time, there was either bullying legislation or not bullying legislation, and then people would say, well, if there's no law on bullying, there's no regulatory tool available to address harassment and bullying and violence in the workplace. And that, of course, is not true. If you're in a jurisdiction that has no labor legislation whatsoever, you're at the bottom of the pyramid, you still have what we call tort law. You can still sue the employer who is oppressing you, or you can still file criminal charges if you're exposed to physical violence. So the idea that there's no legislation in any of the jurisdictions, certainly that concern us, there's legislation everywhere. But it's pretty well, it's not useless legislation, but put it this way, at the beginning of the 20th century, before workers' compensation, we still had tort law, but it wasn't the best tool for the protection of workers' health and for the obtention of compensation if someone was ill. So there is a regulatory framework that underpins everything, but everywhere in Canada, we have workers' compensation legislation from an economic perspective to protect workers' income. Now, I'll be talking about that later on in the presentation. The concepts that we need to retain is the question as to whether there is compensation for all forms of workplace stress or only for acute or traumatic workplace stress. That's a big issue in Canada. I'll get to that later. But from a hierarchical perspective in terms of tools for prevention, it's pretty low on the totem pole still. Then if you're a little bit more sophisticated, you have explicit anti-harassment or anti-bullying legislation or anti-violence legislation. There, again, language matters when you're talking about law, so there's different concepts that overlap, and I'll be addressing that when we talk about the ILO convention. More useful from a prevention perspective is OHS regulation, occupational health and safety laws. Of course, everywhere in Canada, both federally and provincially, we have OHS legislation. We have labor inspectors. The question is, are the labor inspectors empowered to protect workers' mental health? And as you'll see when we get to that part of the presentation, the answer is variable. And it's ideal if the answer is yes, but it's not yes in every province. And in the best case scenario from a regulatory perspective, you have legislation that obliges the employer to do risk assessment with the participation of the workers. My favorite model is the Swedish model, which has been enforced since 2015. There are other models as well, but I personally, and it's a personal preference, I personally think that the Swedish model from 2015 is the way to go if I ran the world, which clearly I don't. So this is something I put together on this slide. This is just about violence and occupational violence and regulation for the prevention of occupational violence. And I put this together for the CFNU. It dates from 2018, so the CFNU is the Canadian Federation of Nurses Unions. I probably most people know that. It's a growing diagram, if you like, in the sense that things are changing. As we'll see at the end of the presentation, Canada has been negotiating, playing a high role in the ILO Convention, which was adopted in 2019, but they've been talking about it since 2015. And in order to be able to ratify that convention, all the provinces have to be able to be in compliance, as does the federal government. So a lot of people are paying attention to violence regulation from a provincial perspective and from a federal perspective. And so occupational health and safety legislation that does address the prevention of violence, of course, addresses part of the prevention of psychosocial hazards. But if you're just talking about regulation on violence, then it's only looking at violence. And here you have the horizontal axis. You see different types of violence. Physical violence explicitly is addressed in every occupational health and safety legislation except that of Quebec. When you have an X in parentheses, that means that they're doing it, but it's not because it's written into the law. And Quebec has been tracking violence and compensation for violence and publishing annually the number of cases that have been accepted and explaining prevention required in different sectors without anything in the law at all. So those parentheses mean that something is being done, but there's nothing in the law that explicitly requires it. When you have a total blank, like Nova Scotia here for psychological harassment and bullying, it means that the last time I looked, and the last time, to be honest, the last time I looked was in December 2019, there was still nothing explicit in the Nova Scotia legislation regarding the prevention of bullying and harassment. They have physical violence. It was among the first provinces in 1996 to create regulatory empowerment for physical violence, but to the best of my knowledge, and people online might know better than I still don't think they've changed their law yet. So bullying and harassment in BC, there's no explicit legislation, at least there wasn't the last time I looked, but they've been doing things. BC has both for psychological harassment, sexual harassment, discriminatory harassment, and even for conjugal violence. It's in the discourse, it's in the pamphlets, it's in the guidance materials that WorkSafe BC puts online, but it's not necessarily explicitly addressed in the legislation, whereas in BC, physical violence is in the regulation. It was the first regulation, not necessarily the best. I'm not going to talk about that now, but the language in BC, I think, is quite weak compared to other provinces. But this gives you an overview, and obviously I'm not going to run through all of these things. Conjugal violence, Ontario was the first province to include an obligation for the employer to protect a worker from conjugal violence if the fact that she was at risk was brought to his attention or its attention. And of course, there's a long history in relation to why Ontario initiated that. And as you can see, it's been picked up in many other provinces, and it's in the ILO Convention. And I'm happy to answer questions on that if at a later date, at the end of the presentation. Now I'm switching. This is trying to answer the question, what can we do to protect workers' mental health beyond violence? So psychosocial hazards, which most people who have been following this series are well aware of, the labor inspectors have the right to do something. So Michel Vézina and Rachel Cox and I published an article on this in 2011, documenting the use of the General Duty Clause in Quebec to protect workers' mental health. The picture that is here, this was the cover of the magazine that the CSST, the equivalent of the Ministry of Labor from in Quebec, in terms of those who are responsible for the application of the Health and Safety Act. This was the front page of their cover because they were very proud that their inspector went into a warehouse in response to mental health problems. This was in 2007. We published in 2011. We're not getting a lot of covers on this, so I don't know to what extent they're still doing this. They're certainly accepting to come in as such, but it's not something that they're making a lot of noise about anymore. And the case, they called him Robot Man, and of course this is an actor. This was technology that was being used in warehouses to improve productivity of workers. They had to wear these headsets that would tell them exactly turn left, turn right. They took away any kind of decision latitude as to how you would stock those shelves. And the reason the inspectorate discovered this was that they were called in for a series of epicondylitis cases among men in their 50s and 60s. And when the inspector went in to try to figure out what was going on, she was shocked to see that these men were all crying, and that this was unusual in her experience as an inspector. And she called Michel Vézina, who might or might not be on the line, who's been following this series, who is a doctor in occupational health, specialized in psychosocial hazards in Quebec. And she said, what do I do with this? And the analysis was done looking at what these headsets were making these people do, and how this could really easily and clearly be documented as something that was really having negative health effects for these workers. So she she used our Occupational Health and Safety Act. So our general duty clause you have on the left-hand side of the screen. This is extracts. Obviously, every employer must take the necessary measures to protect the health and ensure the safety and physical well-being of his worker. It's their words, not mine. He must, in particular, ensure that the organization of the work and the working procedures and techniques do not adversely affect the safety or health of the worker, and use methods and techniques intended for the identification, control, and elimination of risks to the safety or health of the worker. So she put out orders based on those two paragraphs that, in a nutshell, you have on the right-hand side that the technology be adjusted to allow for psychological respite and broader leeway for workers, and that the employer was required to set up a mechanism to monitor mental health problems linked to psychosocial hazards. So this is one case, and it's a case that never went to court. So this is something under the radar screen of people who are interested in regulation from a legal perspective. But it is a very, in my mind, telling exploitation of tools we have at hand. Everybody has a general duty clause. I believe that not everybody has a general duty clause that explicitly mentions organization of work. And I believe that Ontario does not, from what I've been told. But it's still worth knowing that for a general duty clause with no language in the legislation, the inspectorates are using orders. So now I'm going to segue into another piece of research that was led by Greg Anderson at the Justice Institute of British Columbia. I was part of that research, and if the issues that are of interest to you in relation to psychosocial hazards are more particularly associated with first responders and public safety personnel, or PTSD and acute trauma related to working conditions. This is a report that's worth reading. We put it out in August 2019. In that report, we have comparisons of Quebec, Ontario, and British Columbia prior to the adoption of presumptive legislation. So I will explain that in a minute. But what basically they have adopted in many provinces, not in Quebec, but in many other provinces, legislation in workers' compensation that presumes an illness to be work-related if you are a member of public safety personnel or a first responder, and language varies from one province to the other. And the same thing for the diagnosis. Some only look at PTSD, others look at other mental health issues. I'll get back to this in a minute, but if you're a stakeholder is particularly interested in acute stress and particularly interested in first responders and people who are public safety personnel, it's well worth reading this report because there's lots of detail. And my part in there was to look at the workers' compensation cases and appeal prior to the adoption of these presumptions, so that it gives you a good idea of why we need the presumptions, because you could see what was happening to these workers before the presumptions came into play. Okay, now I'm going to give you an overview of compensation issues. Compensation for mental health problems attributable to workplace stress in Canada. This is a very primitive map of Canada, but techno-stress is my personal challenge, so please bear with me. I'm missing Vancouver Island because I didn't know how to put it back in. But this is an overview of the jurisdictions. So what you can see, and the first take-home message is that all jurisdictions in Canada for workers' compensation compensate for mental health problems attributable to acute stress, or in many provinces they call it traumatic stress. There is no legislation in Canada that says we do not cover traumatic stress. 5 jurisdictions in Canada, the mauve or the light violet jurisdictions, always compensated for mental health problems attributable to chronic stress as well. And you have the list on the right-hand side of the screen: Yukon, Nunavut, Northwest Territories, Alberta, Saskatchewan, and Quebec. And when I say they always compensated for problems attributable to chronic stress, that doesn't necessarily mean they did it well, but what it means is that there was nothing in their workers' compensation legislation to preclude compensation for chronic stress. And there are no special rules in the workers' compensation legislation that make it more difficult to get compensation because you're claiming for a mental health problem attributable to chronic stress. And I'm well aware of the fact that it's not always easy to get compensation, but there's a big difference between being told you can't even apply because it's not covered in your jurisdiction, from being told, well, apply, you're going to lose, but if you go into appeal, you have a 50-50 chance of winning, which is basically the situation in Quebec now. It's better than it used to be, but there are thousands of people who are compensated every year for chronic stress in Quebec. BC and Ontario, as you can see, are sort of an ochre color, and they're in a process of transition. And both British Columbia and Ontario, we're like those darker provinces. So we're like Manitoba, Newfoundland and Labrador, the Atlantic provinces, that in that they explicitly excluded chronic stress. They only covered traumatic stress. BC was told, I believe in 2009, that that was unconstitutional by the BC Court of Appeal. And Ontario over and over again was told by the WSIAT that the exclusion in Article 13 of the WSIA, the Worker Safety and Insurance Act, was unconstitutional. So they actually changed their legislation recently, and I'll talk about that change in a minute. So they're basically, the bottom line is, if you're from an ochre province, know that you are in a province where they're practicing compensation for chronic stress, but they haven't gotten very good at it yet. They've got lots of really technical rules. Quebec has been compensating. The first case that I was aware of was 1985. And so we've been building from a case law perspective. We've got decisions from the Court of Appeal. We have sort of a system that works, that's difficult, but everybody knows about, and people know how to represent workers in those contexts. So that's the overview for the law in all jurisdictions in Canada. And now, just in case this is language that you're not familiar with, just the basics on what I'm talking about here. So a mental health problem can be triggered by an acutely stressful situation, a traumatic event, an armed robbery, a hostage taking, attending a motor vehicle accident with fatalities, or it can be compromised by chronic stress, which in our case law in Quebec, we say a series of even banal events that cumulatively undermine mental health. And if you're a health professional, you know that these are not binary variables, that there's a huge amount of territory in between the two. If you're a first responder, one of the big problems for ambulance technicians, for instance, was that the boards across Canada were saying, well, you're used to finding dead bodies, so this is not a traumatic event. That's why we have a presumption now, because that case law was so, and that board policy was so bad for workers' health that they finally realized that this was not a good approach to these issues. But in any case, your concepts appear to be binary if you're just a lawyer, but if you're a real life person, you know that there's a whole spectrum between acutely stressed and chronic, acute stress and chronic stress, and in most cases they're somewhere in between. So the case law in Quebec, which is constant, there's no debate, an accumulation of events arising out of or in the course of employment, that's our law, but it's the same in practice as what's going on in the other provinces. Events which, when considered individually, may seem banal, by their cumulative effect become significant and meet the legislative requirement for a sudden and unforeseen event which is the definition of work accident. And we, of course, require medical evidence that will permit the tribunal to conclude that the cumulative events contributed, and significantly is not always required. It will be if you've already had a series of mental health problems, to the diagnosed mental health problem. So basically, take-home message here is Quebec uses the accident definition. All our studies have shown that of the appeal decisions, 91%, 90 to 91% of the appeal decisions, I've done 3 longitudinal studies over the last 20 years, they're all accepting them as accidents. They're not accepting them as occupational disease. Very occasionally we'll have a case accepted as occupational disease. And this is constant. You see there's sort of the grain of sand. So if you're a person of color and somebody doesn't say hello to you one morning, that's a grain of sand. If it's been a year and they say hello to everybody else except you, the cumulative effect of something that in itself could be banal the first time it happens becomes a work accident, and it's a compensable work accident. So note that Quebec has been covering this for decades. The word mental health is not in the legislation, either in the compensation legislation or the prevention legislation. Chronic stress at work, and this is the threshold, the legal argument, which doesn't make it easy, but it's easier than what's going on in the other provinces. It's necessary to demonstrate that the stressors individually or cumulatively go beyond the normal workplace stressors to which workers are exposed in the modern workplace. And the trouble with normal is that everybody has their own idea what normal is, so there are thousands of cases that we can discuss were we to want to, and I've certainly written about them. But it's all around, is this normal? And depending on whether it's normal or not, the outcome will be predicated on that. Claims alleging that legitimate management practices have led to mental health problems are not accepted. And it's important to realize, because now other provinces have started to use this, and it doesn't mean that if it's a management practice, you're not covered. So if it's an abusive management practice, it's compensable. The idea is, and this comes from the Americans, my first study was published in 1989. We looked at the 50 American states. And essentially, if somebody loses their job because of layoffs, they might become depressed. We don't want that to be compensable. And that, I think, is a reasonable limitation to the compensation legislation, because, you know, look at what's going on right now. Everybody who's losing their job are going to be depressed about losing their job. Doesn't make it a workers' compensation issue as such. The best illustration of how this applies is we have harassment legislation. It's the first in North America, came in 2004. A woman was accused of harassing somebody else, and her employer went into her classroom. She was a teacher, and said, "Get out, you've been harassing people and this is unacceptable behavior." And she attempted suicide, and that suicide was found to be compensable. Even though it was a legitimate management practice to discipline somebody who is a harasser, it is not legitimate to do it in a way that is in violation of the person's dignity, and as such, that became a compensable injury. So prevalence of violence in the workplace as such, and I'm just checking the time, which I'm trying to figure out. Okay. I don't want to go into too much detail on this, but we have a representative sample of Quebec workers, a study that took place in 2007-8. Speak about it in a minute. And from that study, 14.8% of workers were found to be targeted of psychological harassment in their perceptions. And that, by the way, in this follow-up study is up to almost 21%. But when we look at the compensated claims in 2011, so it's not the same year, but it's it's 2015 rather. It's only 1.5% of the compensated claims. So clearly the chronic stress and psychological harassment and sexual harassment are forms of chronic stress. They're undercompensated in the compensation scheme. Physical violence is almost 85% of the claims for physical violence were covered by the CSST. And then there's 14% other forms of violence. So what's clear is that what's making people sick is not necessarily what you see in the compensation statistics. This is my data that comes out of reading hundreds of appeal cases in Quebec. It's published if you're interested in the details. And as you can see, if you divide the screen into two, on the left-hand side, it's a study of cases between 1998 and 2002, and in the right-hand side, it's 2007 and 2008. And the take-home here is we wanted to rank the psychosocial hazards that workers were talking about in their appeal cases, trying to get compensated for chronic stress. And on the left-hand side, the first column here, I don't know if you can see if I put my mouse here. So excessive workload, just so that you can see how to read this, was 97 of the 357 cases, the workers were talking about excessive workload. And of course, they could talk about 3 or 4 or 5 or 20 psychosocial hazards. I've just put the top 5 here. So the top 5 in the first period: excessive workload, lack of support by the supervisor, heavy responsibilities, lack of control, and lack of recognition. On the other hand, the cases where the workers actually won, the argument or the factual situation, people with heavy responsibilities were getting compensated for not being able to, for developing mental health problems related to that, 62% of the cases. Then lack of support by the supervisor went down to 57%, and the other 3 is about the same, 39, 37, 36. So a little over a third of the cases with those psychosocial hazards were being compensated. We redid this study 2007, 2008, and number 1 now is lack of support of the supervisor. Number 2, which is a big drop from 154 to 67, is excessive workload. And then you have the others, as you can see here. And what's being accepted is lack of control, which is kind of interesting because that teaches me that the people rendering the decisions, and perhaps because of the experts who are testifying, are starting to understand CARESEC, high demand, low control, and what that can do to people's mental health. This stuff I do, it's about compensation to define what we should be preventing in the workplace. And as you'll note, none of this is about violence, right? Criteria to access compensation in BC. This is when I said that BC is now ochre in my map. They've changed their definitions. They say acute stress is a reaction to one or more traumatic events arising out of and in the course of the worker's employment. That's classic. Chronic stress, they say, is predominantly caused by a significant work-related stressor. So it's not a banal stressor, a significant work-related stressor, including bullying or harassment, or a cumulative series of significant work-related stressors arising out of and in the course of the worker's employment. So 2 issues that make it a lot more narrow than Quebec. First of all, banal issues are not being covered by this. Secondly, predominantly caused raises the bar in terms of causation. Personally, I think it's still unconstitutional, but that's, it's easy for me to say. I'm a law professor, so there you go. Criteria to access compensation in Ontario for traumatic mental stress, the WSIB must be satisfied on a balance of probabilities that the traumatic events or the cumulative effect of a series of traumatic events arose out of in the course of employment caused or significantly contributed to an appropriately diagnosed mental stress injury. So for traumatic stress, it's very similar to what Quebec applies for all stress. But for chronic mental stress, again, we keep the balance of probabilities, but we talk about a substantial work-related stressor, arose out of the course of employment, that's fine, and was the predominant cause. Again, like BC, I think this is raising the bar in a discriminatory way and would probably be vulnerable to a charter challenge. Okay, so the role of legislative presumptions. This is about the presumptive legislation that was adopted in Ontario and BC, but pretty well every province except Quebec has adopted something, and it's different from each province. So in Ontario, the presumption only applies to post-traumatic stress disorder. In BC, it applies to a mental disorder, so the language is broader. Depression can be a diagnosis that would be covered. And the mental disorder must be presumed to be a reaction to one or more traumatic events arising out of and in the course of the worker's employment, unless the contrary is proved. So instead of the worker having to say, I'm seeing my 60th dead child in the last year, and that's the one that made me sick, if the worker is an ambulance driver, a first responder, and he or she has a diagnosis of PTSD, it will be presumed that the PTSD is attributable to the work, and the employer can still try to prove the contrary. The diagnostic requirements in this legislation, conditions for application of the presumption in BC and Ontario, you have on the right-hand side. As I said in the previous slide, in Ontario it's only PTSD or other diagnoses. BC and Ontario require a DSM-5 diagnosis by psychiatrists or psychologists, and that's not true in Quebec. The DSM is explicitly not required according to case law. The Diagnostic and Statistical Manual of the American Psychiatric Association is not the requirement for the diagnosis in Quebec. There is no presumption in Quebec, but it's the general conditions for compensation that apply. In all provinces, very clearly, if you get a doctor's note that says Katherine cries all the time, this is not a disease and this is not compensable. It has to have a diagnosis, but it doesn't have to be a DSM-5 diagnosis as it does in the other provinces. A couple of words on voluntary standards, and I think other people have spoken to this in the past. Just from a legal perspective, note that a voluntary standard is not law. So we aspire to respect the National Standard of Canada. You could try and get it written into your legislation indirectly using it as part of the General Duty Clause. And there is case law in Quebec for ergonomic standards that go through the General Duty Clause, but it's not law. It's not law, and there are now a few evaluations, and in a nutshell, this particular evaluation, which I think is an important one, underlines the limits of voluntary standards. The suggestion from these findings that organizations most in need of implementing the standard may be the least receptive. So if you're working in a place which is being run by people who have a sort of military approach to management, they're not going to want to look at the standard. This is what's suggested here. And the other point that they make is that there appears to be a tendency to view mental health as an attribute of the individual. And of course, from a prevention perspective, this is not helpful. So I'm now in closing, and I'm not going to close right away. I'm hoping I still have a little bit of time. I'm going to talk a little bit about the ILO Convention. I think I have 3 or 4 slides on this. So the first piece of information is there is an ILO Convention on Violence and Harassment in the Workplace that was adopted in 2019. If you're interested in violence and harassment in the workplace, there's a wealth of educational material associated with this process. So there's what's happening in every country in the world, how this is organized, how things are defined. And to date, no country has ratified this convention. I was told before we actually had a convention that Canada was hoping to ratify it. So this is, in other words, a tool from a political perspective to try to convince your local governments that they want to get their legislation in order so that we can ratify it. So definitions of occupational violence, I'm not going to run through these. You can read them on the left. But what's important is that there's a very broad definition in the ILO Convention. The term violence and harassment in the world of work refers to a range of unacceptable behaviors and practices or threats thereof, whether a single occurrence or repeated, that aim at, result in, or are likely to result in physical, psychological, sexual, or economic harm, and includes gender-based violence and harassment. Determinants of workplace violence are discussed in the convention itself and the recommendation. And we know from the literature that accompanies the adoption of the convention that psychosocial and organizational risk factors relating to occupational violence very clearly shown for job strain, ISO strain. I'm presuming this is the Karasek model, high demand, low control. High demand, low control with no social support or low social support is ISO strain. Segrist's effort reward imbalance, restructuring and job insecurity, precarious employment. There is quite a lot of literature that says that these psychosocial hazards are associated with different forms of violence. And in the convention itself, I draw your attention here, this is Article 9, where each member, which means each state, shall adopt laws and regulations requiring employers to take appropriate steps commensurate with their degree of control to prevent violence and harassment in the world of work, including gender-based violence and harassment, in particular as far as reasonably practical to take into account violence and harassment and associated psychosocial risks in the management of occupational health and safety. So if you are in a province that doesn't have work organization in your general duty clause, this is the argument to say that in order to be able to be compliant with the ILO convention, we need to have joint health and safety committees or equivalent worker participation in managing psychosocial risks in the workplace to prevent violence. And now I believe I'm almost done. I don't know, Val, how am I doing for time? Should I stop or should I keep going? Is anybody there?
Mike's sorry, my mic was off. I think we are pushing your time envelope, but if you have a couple more points, I think people are probably really interested in the contents as well.
I'll try and do this within like a minute, so I'm going to run through it quickly. I told you in the beginning about eco-tests. These are the references. Among the many, many things that we studied in eco-tests, we saw the big orange bars. These are among the people who are harassed in the workplace. They're the association with the psychosocial hazards to which they're exposed. So that's a demonstration. You have the list at the bottom. You have the list at the bottom: emotionally demanding work, lacking means to do quality work, impossible to take a break, impossible to modify the workplace. All of these psychosocial hazards have been shown to be associated with exposure to harassment. So in conclusion, legislation that promotes risk assessment with the participation of workers is the most effective. It's no need to explicitly include mental health in the legal language, but you have to make sure that you're not excluding it implicitly. And Ontario, for instance, Bill 168 in 2010 actually had the effect of narrowing the inspectors' powers. If they hadn't done anything at all, there would have been more powers for the inspectors to prevent violence and harassment. Workers' compensation for chronic stress is a key tool for prevention because it makes visible the working conditions that make workers ill. It makes the business case for prevention. It starts costing money. And it facilitates appropriate measures for return to work if you have a decent workers' compensation system. And the last point is that the ILO convention may provide an incentive for better language on risk assessment of psychosocial hazards. So that's it. I'm done. And then the rest of the slides, as you'll see, are a bunch of references that you're welcome to access.